All right. Good morning. It is March 19th, the Senate Judiciary. We're taking H2. Once again, we have a couple of folks from DCF getting a sense you're all going to present kind of together at the same time. Okay.
Yes.
Sounds good. Floor is yours. Thank you.
Thank you. Good morning, Mr. Chair, members of the committee. My name for the record is Erica Radke, and I'm Deputy Commissioner of the Family Services Division of DCF. I have with me here today Lindy Boudreau, who's the Director of our Adolescent Services Unit, and remotely Tyler Allen, the Director of our High-End System of Care Unit. He's coming in from sunny Arizona. So thank you for inviting us to testify about H2. We really do appreciate your focus on this bill, particularly given the time pressures at play. I do want to respect everybody's time, so I'm going to keep my remarks pretty brief, and then we will be happy to answer any questions the committee might have about our work as it relates to H2. So first off, the department is definitely in support of H2 in its current form. Raising the minimum age for delinquency from age 10 to 12 is really in alignment with our focus and our values as a division because of our trauma-informed approach is something that the department truly endorses. And also the numbers that we have pulled really indicate that this change would not have a significant pressure or a significant increase on our workload. With regard to the raise the age portions of the bill, as a result of the juvenile jurisdiction expansion, which began in 2015-16 session, around there, DCF has really been tasked with being able to address more needs, but with less access to programming. So despite considerable efforts to expand our service capacity, the Family Services Division really just does not have all the programming that we need to manage our existing population. So for this delay that's provided in H2 is really crucial for us to have any chance of a successful implementation of the next phase of Raise the Age. We would definitely be in support of having that type of delay. Now, I do need to say that even with the delay, and I can't guarantee that in just 2 short years, our system of care would be robust enough to actually accommodate the additional youth. But I do know that the reporting requirements that are part of H2 give a really good opportunity for the committee to keep a track of the progress that we're doing. And although I can't guarantee we'll be ready, but I can guarantee you is that we are going to continue to do our level best to bring the supports and services that all our youth need. And I'm looking at doing that not simply from a quantitative aspect so that we have more services and supports, but also a qualitative aspect so that the supports and services that we have for our youth really are value added and give them an opportunity to not only be law-abiding, but to move on to have successful, productive years here in Vermont. Now, there was some testimony that yesterday that occurred that we're talking about some of the numbers, where we get our numbers as far as our caseloads and how we count the youth that are in our work and that we anticipate could have an impact if Raise the Age for the next phase we're implemented. So before we move to questions, I would really like to give Lindy an opportunity to walk you through our report, sort of give you a real good understanding of where we get the numbers from for our caseloads and how we anticipate the potential impact of raising the age to that next phase and how that can impact our caseloads. Let me turn it over to you.
For the record, I'm Lindy Boudreau. I'm the Adolescent Services Director at DCF. Tyler, can you pull up the handout? Thank you. So I just wanted to provide clarity. Tyler, you can just show the graph. First graph. Thank you. Just wanted to provide some clarity on testimony that Matthew Bernstein provided yesterday. So this information was in our January Raise the Age update report, and it's going to be in our March 31st report as well. I wanted to provide clarity on what these numbers actually represent and the reason we're putting this information in this report. So we, at Family Services, Matthew testified yesterday that our family services worker carried mixed caseload. That is true to a certain extent. So what this data is representing is the caseloads of the folks who are actually providing support to justice involved youth or raise the age youth. But they also have responsibility for providing supports to what we call the at-risk population, which include youth who are beyond the control of their parents and youth who are truant, as well as the delinquency and youthful offender populations. So we felt it's important to include this information because if we're looking at the impact of additional numbers through raise the age, these are the caseloads that it will impact. So the data that Matthew referenced yesterday was a data chart of all of our caseloads on DCF. So it's not really an accurate representation of the impact on the staff who are actually providing the supports to this population, which is why I'm showing this graph, because these are the folks who are going to take those cases on. Just another piece to note about this part of our workforce is that these staff, if there are overflow needs from the child protection side of our work, it rolls to these folks. So they also, when there's a need within a district to pick up child protection cases, they also have to pick those cases up as well. So that's why we're showing this. The top part, as you can see, is the at-risk population. And I apologize, the black doesn't come through very well. So I'll have to fix that. But the bottom portion is the delinquent youth. So you can see 2020 is the year that we began the raise the age, the 18-year-olds. Juvenile jurisdictional changes started in 2016, as Deputy Commissioner indicated. At that time, we went from 16 and 17-year-olds, and then we jumped to the 18-year-olds in 2020. And prior to that, 2018, we had a significant impact on our caseload when the juvenile jurisdictional changes included expansion of our youthful offenders from age 18 through 22. We had an increase from 33 the year before to 504 1 year. So that significantly impacted our caseload. So this, as Erica mentioned, this has been a cumulative impact. It's not just about raise the age, it's about all of the jurisdictional changes that we've been a part of, I've been a part of with the department since 2015.
Sorry, could you just repeat that youthful offender?
So sure, 2017 for the entire year, we had 34. The next year after we implemented the expansion, we had 504.
And what is it at now?
I don't have those numbers. I can get those numbers to you. I apologize.
Thank you.
And just to be clear, those are filings. The difference between a delinquency filing and youthful offender filing is that with delinquencies, those cases may go different places before they become the responsibility of the court or DCF. With the youthful offender cases, that same year, in 2018, we also changed the process so that we introduced 2 additional court hearings. And so with that filing, that prompts DCF to do a report. So with all of those cases, there's like I would say front loading of work. Even if that case gets diverted later, we have to do the report first. So that there's additional workload at that level.
And for those YO cases, it's not just the attorney that gets assigned for the family division. There's also one that gets assigned for the criminal division.
Well, it depends. So they can start in the criminal division if the case begins in the family division. The criminal division, they can motion down for youthful offender status. And then the criminal court case is on hold. And then so the family division takes over. So that attorney, depending, it might be if it's an attorney that covers both, they might follow that case. Or they would just they would give them the attorney in the family division. So that's, I just wanted to provide that clarity, and all of our, I know Matthew also testified that our offices do not hold juvenile justice specific caseloads for family services workers, and that's actually not true. We do. Each office has dedicated staff. As I mentioned, some of our bigger offices, like St. Albans, Gary, Burlington, they have, an entire unit of staff that provide support to this population. But I thought it was important to show the actual impact on the folks caring for it.
So thank you for the graph. I think that's easy to get a look at it. I'm wondering, so we're talking about caseloads going up to the point where it strains the staff. Um, Hiring or adding resources seems like one way to reduce that number. And since the population is not going into one part of the system, but now another, you should theoretically be saving money on the other side, since this population is not going the direction they would otherwise go without raising the age. So my question is, why, just in general, why is money not being diverted from one part of the system to, in other words, i.e. the governor's recommend? Why not ask, because we've been at this for some years now, why not ask for more case managers or people in your system and base it on reducing the number of people who may be going on the other side, on the criminal side? Any thoughts about that? Does that make sense?
You mean if we have more juvenile justice workers, then we should be able to have fewer caseload,
Per
additional.
worker.
Mhm.
And also where those people are not, because we're using raise the age, they're not going into the adult system, they're going into the, you see what I'm saying?
I'm in charge of it. So DST savings.
So it seems like, you know, just basically we would be adding more people to your staffs to deal with raise the age. But I feel like instead we talk about the strain on staff because we're artificially constraining the number of people dealing with. That makes sense. Is there a problem hiring? Because I know that hiring is an issue.
Hiring definitely is an issue with the family services division. It's, we have a need for workers and a need for case workers as well. And we don't seem to be getting the same amount of people interested in these types of jobs since the pandemic. And also some of the quality of the people we are getting just aren't suitable for this work, which is, it's really hard and you need somebody that's dedicated and is willing to stay. So we have been trying to do different, modes of outreach, going to colleges, doing job fairs. And we actually have seen a benefit in changing the way that we do LinkedIn as far as making more targeted approaches for workers. So it's starting to improve, but it hasn't, it's not yet where I can say we've got a full staff of people. And even then, when we have new workers, there's a 6-month training period where they can't get a caseload because they're really still learning. So it's sort of a dance between getting the people and getting them trained and get the people that have been here and burned out leaving. So we're sort of just trying to maintain at this point.
Yep. But I guess the basic question would be, is there a willingness on the governor's part and the department's part to hire to the extent needed as shown on the graph?
I think that right now it's we have spaces. It's more not an unwillingness to hire. It's trying to find folks. I think that if we had the folks, we would be able to. It's sort of we're really making concerted to find those people. So we do have some spaces that we would be able to build in with people and train them up. It's just that finding the right people.
Fair enough. Thank you.
And I also have regarding Department of Corrections savings, this was a topic that we talked about over the years throughout the correction raise age. And for this population, they don't, there's not large numbers that actually wind up being served by the Department of Corrections. And I was realizing as I was saying, I don't have the numbers with me, I can get them. I'll reach out to the Department of Correction for those numbers. But that's been something that's been like the options in the criminal division for youth who are charged criminally and the options that we have in the family division are not the same. So yesterday, Marshall Matthew mentioned diversion or direct approach to barge or fine only. Fine only is a big number for this population, 18-year-olds more so, but definitely 19-year-olds as well. That's not an option that we have in family division. In the 2009 report, the raise the age report that we wrote in 2019, I was a part of that for family services, and part of what we explored in that report was looking at alternatives to expand fine only instead of fine only. And so the group decided that fines don't work, especially when you're looking at this population. You want to move the dial with them. It's around rehabilitation and treatment, not just saying, hey, you have $100 fine and we're done. That doesn't prove to change these behaviors. So there was an agreement with that group that we would not proceed to have fine only dispositions in family division. So that's not a number. But a number I'll just say has been hard for me to obtain from the court, because we don't do it by get that information from the court. But that is a number that impacts what comes our way versus what gets prosecuted in disposed. So I think that's what really impacts a lot of the lower level cases for DOC. So that's why there's not, it's apples and oranges to a certain degree, because there's not that vacancy savings there. They don't serve those.
Thank you.
Thank you. The fact that fines don't really work would to me be a reason why we should be moving these youth into the supportive treatment setting. And my question, this law passed in 2018, and every year we've heard that we can't keep it going, we can't keep going. So what are the barriers? I mean, it's been 7 years since this law passed. And so to me, it feels, and we had this conversation last year as well, really challenging that those steps aren't happening to get us to where we can move forward with what the data show works better. So what's being done to get us there?
And I think that is really the meat of the report that Lindy and Tyler have made sure talking about the various steps that we're taking. It's just that they're not steps that are going to be quick. Sort of like if you have the Red Clover program for justice involved youth, but there's also the need to do work with youth with the TS needs. There's additional supports and services that are dependent upon our hiring or getting staff, not FSD staff, but contracting out with workers to do these types of things and having these types of supports. And what you find nationwide, this is not an area where it's easy to find workers. This is not something limited to Vermont. Like if we want to stand up a program for youth with significant mental health challenges, you can put out an RFP, may or may not get quality vendors to apply. Because for me, we have these needs, but I need to make sure it's the right people and right organizations that are supporting it, as opposed to just putting out an RFP and getting somebody and that's not going to do work. I need to support the kids in our system. So it's not something that's going to be overnight, and I do think that it's been a while. And all I know is that we're continuing to make efforts and having significant progress in the last couple of years, which is why Red Clover is up and running, and that was not an easy feat by any means to get that going. And we're going to continue to make those moves, those initiatives, because even without race stage, I still have the skills I need to take care of. So these are things that we continue to work on.
I appreciate that, and I appreciate the work that you're doing to support youth. And a part of me feels like if you can just come back every year and ask us to extend it again, it's never going to happen.
I hear that. And the thing is, I guess I would say even between what we've done in the last 2 years and what we're doing now has been a great deal. We actually have a secure facilities. So I think that it may not be as fast as any of us want, because remember the types of supports and services that I'm trying to put in place. If they're not in place, that work falls back on my staff. So I want it as much as anybody in here. It's just that it is not as quick as we would like. But I would ask Lindy and Alicia.
Sure, Tyler can certainly speak to some of the additions regarding the broader system of care, but one of the things when I was talking about the impact on our workforce and the youth that we're serving over the years, what's happened with those conversations, like I mentioned, is really focused on just the raise the age population. And it's for us, it's not, it's everybody that we are mandated to serve. So some of the things that have happened over the past couple of years since this passed is we certainly didn't expect a pandemic. That really stalled a lot of, and I don't blame this on the pandemic, I don't. But it really stalled a lot of things, just the work process, like moving kids through the work process, we're seeing year delays right now with some cases. So it's really hard for us to have an immediate response and provide that support when kids are lingering through the work process for over a year. And so I'm hoping that in the next couple of years, we'll kind of shuffle through the what we're calling the bogged down work process, so that kids can have a quicker response. We're also seeing with certainly with the opening of October, that's helpful. It's a little bit of a pressure valve on our system of care, but what happens with it and what has been happening is we have those youth who they make the news in some circumstances or are the top tier youth. We have other youth who are in programs that are stabilizing and doing well, maybe waiting for another placement or waiting to transition home or back to the community. And those higher youth bump those kids out. So then those kids go down to the next level and then they start disrupting. And then the kids below them, get displaced. So that's what I'm talking about, the bigger impact. That's what's happened over the past couple of years. The other significant piece of this that I would say impacted our system of care was the closure side. We certainly understand there was a need to close Woodside, but a certain purpose in our system of care that met a broader need. And so that's why we had, 4 years to the day before Red Clover was open from when we closed Woodside. That's a long time for our system to be able to provide that level of support to you. So I guess I'll say that. And I don't know, Tyler, if you have anything additional you want to add?
Actually, Tyler, before you speak, I did want to add in a couple of other things that are not necessarily, that could be for justice involved, but not necessarily that are in the works. It's a 2-bed program in Wyndham, and we already now have a dedicated bed just for juveniles, the VCIN bed. And these are all things, it's part of our system that do take off pressures so that we can continue to do the work that we need to do. So the years have gone by, but we haven't been, I guess that's what I want to point out. But another thing I should say is, and Tyler's position is actually a new position that I created, dedicated strictly to being a director for high-end system of care teams. And that's a nice tie-in with juvenile justice involvement as well. So I hope that Tyler could add into this discussion.
I would love to. Thank you all. For the record, my name is Tyler Allen. I'm the High-End System of Care Director, as Deputy Commissioner Radke said earlier, for the Family Services Division. A couple, I guess, just finer points I want to put on some of the things that both Lindy and Erica have shared with the committee. One of the things that I'm contemplating is the graph that we looked at in the beginning of this that shows this kind of elevating case rate across our at-risk and delinquency populations, our justice-involved youth, so to speak. And we talked about that within the context of the portion of our workforce that is specifically dedicated to working with those youth. And while I think there could be a number of reasons we see that expanding, I think part of what I think about is we have a justice involvement population that is growing over time, concurrent with an overall child welfare population or overall DC Family Services Division case counts that is decreasing. And so some of the questions that come up for me is why does that happen in this way? And one of the maybe assumptions I make in that is for lack of access to system of care. And what Lindy mentioned earlier was the closure of Woodside. That was a portion of it, and the strain that put on our crisis stabilization network, because youth who typically would have been served in the Woodside program are now going elsewhere. And what we are finding nationally is our access to programs that support adolescents with aggression in their case profile is diminishing every year. The primary out-of-state PRTF program that we could count on for a placement with a youth who has aggressive behaviors as part of their case profile closed their doors to all out-of-state residents just a couple months ago. And that is a national trend that's happening. A lot of those programs are just becoming increasingly resistant to serving that quote unquote type of kid. And so I really appreciate Senator Vyhovsky, your kind of assessment that the kids we're talking about here, we don't want to be measuring them based on purely law abidance. This is not about measuring somebody in terms of criminality. This is an acknowledgement that there's a therapeutic intervention needed, that there's opportunity, that their law abidance challenge brings us some opportunity to gain them access to therapeutic programming. Unfortunately, we are losing the capacity to find programs that will accept them. And so that's part of the urgency behind developing the Green Mountain Youth Campus, because Red Clover is wonderful. They're doing wonderful work. They're very successful with the young people being served there so far, but it is a small program and it is designed primarily as a crisis stabilization program, which means it's supposed to be as short-term as possible. And so what we would like to see is programmings where there is thoughtful long-term treatment put in place for individuals who have law abidance challenges as well. So that's why there has been some emphasis on developing Green Mountain Youth Campus, or more secure programming. And I think when you kind of just step back and look at whole caseloads on a whole, it doesn't necessarily do justice to this population has some distinct needs. And the last connection I want to make was in response to your question, Senator Baruth, about the, to some degree, what's our commitment to hiring more staff to serve this population, but also should there be some efforts towards rebalancing our existing staff if we're seeing a growth here. And I just wanted to add on, there is additional skill set required to work with an adolescent population. I mean, I think all of our staff have the capacity to serve it. It's within the job description, but working with youth as a probation officer, interacting with the court more fully, there's more steps involved with that. There's specialization that's required. And so that's why there does have to be some focus on who is going into that role, who's willing to do that role, and are they properly prepared to do the role. So I think that's part of what's slowing us down. And I just really want to also at last appreciate what Deputy Commissioner Radke was saying, is that we have made great strides. And that as we make strides forward in one direction, sometimes the sand shifts on us in another direction. So we acknowledge that we developed some crisis programming for youth with developmental needs. That's entirely separate from the raise the age population, but it is very much what we're referring to our high-end system of care. We have youth with medical complexity that we're having to do staffing patterns around and working in concert with hospitals and so on and so forth. And all of those things kind of stress and strain this workforce differently due to acuity of therapeutic needs. And they interact with our ability to be able to advance this new proposal. So I think we're moving forward on all those fronts. That's why some of our solutions are short-term, Band-Aid to get through today, and some of our solutions are long-term, and then we have some in the middle, and those are laid out in the report with some thoroughness. And so I just want to put that out there, that we're quite a bit farther than we were before, and I think there is still some more room to grow, but I feel like we're getting closer, and hopefully my title is going to be just a term of art that disappears in time, because we won't have to refer to a system of care as a high-end system of care or otherwise.
Thank you. My understanding from a service provider in my community is that recently a transitional housing program was closed for justice involved youth 18 and 19. So that to me feels like it's a backward movement. So what's happening there? I don't want to. Someone just in my community let me know that that was a recent change due to not applying for federal funding or something along those lines, and that's all I know. And so I'm asking you all if you know more.
No, I'm not. Tyler, are you familiar with the program recently closing?
I'm unaware of that program. There's one guess I might have, that we did an exploration with the development of the Green Mountain Youth Campus to include an 18 and older wing of that program. We ran across kind of multiple complications and what that looked like. And so we did take that out of our plans and reverted back to what our original design element was. But that is not about a program closing. So I'm unaware of the program you're referring to, Senator.
We have two programs that we have through DCF that provides 4 states to 19-year-olds, and that's Return House, which is located in Larry. And then we have 208, which is located in Edmonton. So those are the two that we oversee. If it's a transitional housing program, that to me sits outside of DCF.
And maybe there's a misunderstanding as to who is running that.
And I would say that with Return House, it had been sort of a joint EOC, and we were working with them as well as DCF, but our commitment to working with this over 18 age population, we have taken over that program. It's only a DCF run program as well. So we are interested in working with these kiddos as best we can. And I know with that 208 program, I believe that it's not the program where we can have someone come in, they're over 18 and there really gives them a good chance to sort of launch themselves into adulthood. And we have supported that fully.
My last question, and it is to Senator Bird's point about cost savings. I don't know, and I don't know if there is a way of tracking this or if you are tracking this. But to me, the cost savings aren't simply, is this youth currently incarcerated, but it goes to the broader picture, because I've seen the research that shows that youth who are served in a juvenile supportive setting are significantly less likely to commit crimes in later adulthood. And that is cost savings to the system. You know, every young person who goes through your system and never commits a crime again versus someone who goes through and escalates, you know, the way they engage with the criminal justice system is cost savings. Is that broader picture being looked at?
I mean, I can certainly say again, when we're talking about the criminal cases for this population, again, it's very small. It's not just on incarceration. When I talk about being served by Department of Corrections, that includes community probation, as well as another option that they have that's different from ours is it used to be called administrative probation. I'm not sure exactly what it's called. Basically, phone-in supervision. So that for them would require a lot of actual manpower, because it's just a phone-in. That's a form of supervision that they provide. So I think, again, when we're looking at this population, I'm not sure that there's a large number that actually have ongoing supervision outside of incarceration. And if you look at the incarceration numbers, we're still very similar. I don't know. Do you know any regarding that?
I'm not sure if they're tracking that, but I do need to hear and understand the larger point of the more kids we can get to serve and have more treatment-based focus. They have that better, hopefully that better life, you know, law abiding and moving forward. They are not abstracting the system and continuing where it's more of an expense. And you know, the expense is one thing, but for us it's really more that we're giving them those better life chances. But I think the larger point is we need to be able to do it well in order to provide those better life chances. And at this point, we don't have the supports and services that would be helpful.
And also just another point, these 19-year-olds will continue to be served as youthful offenders. So I suspect that the majority of those cases will still come to DCF for consideration for youthful offender. So they're still being served by Family Services Division, to be clear, and the OC, because those cases have joint supervisory requirements by statute. So the majority of cases come to Family Division for consideration for offender status from the criminal court. So even though those cases start there, they often come to us. So for every charge. So if it's a minor thing, if you doesn't want to consider an alternative use criminal division, then the case comes to us for consideration. So we perceive those, we're serving those youth. Maybe not all of them, but there's still an opportunity for an approach that is sitting with the
If you're already serving youth we're talking about, I guess I'm even more confused as to how there's going to be a huge increase in burden.
Well, the difference is it's hard to explain. So with those cases, they do not end up on our we may not get supervision of them entirely because DOC, we have what we call lead agencies when it comes to DCF and DOC. So those cases might primarily sit with DOC as the supervising agent. So it may not be that we have the entire impact, but the workload for DCF is front loaded, if you will, because we have to write reports. DOT weighs in on reports and adds their thoughts to it, but we're that agent that is responsible for writing those reports and being the population report system. And some of those cases may not stay with us, so we may have a burden at the beginning, and then the court decides that safety cannot be afforded, and the case is returned. So it's a split. When I say, and I should clarify this, when I say that they may come to us, when I say when they come to us for consideration, that doesn't mean that they're going to be served with findings. It's that our system is looking at whether or not they're appropriate for that. So sorry, that's the difference.
Whereas with raise the age, they do, they're definitely managed to us and they'll require all that front load. So
Yes, sorry for that.
You
One
speak the
question.
language every day.
Yeah, sorry.
One question I have for you, I'm curious, regarding supports and regarding, the lack of a better word, the boots on the ground workers who are doing this. Would DCF, and it's not that I'm doubting anything you're saying, but would DCF be willing to provide any direct testimony from workers who can say, here's what our day-to-day is like, here's what our workload is like, and it would be great if the legislature could fix X, Y, and Z, or it would make our lives easier. And I think that would give at least me a perspective on some of the things we could change to progress this along, hopefully within the next, I don't know, decade, right? But
we would be happy to do that. Actually, we did have a family services supervisor, Nikki Durant, who has a caseload focused in juvenile justice, testify for the House just last month. So, and she testified about raise the age and what would be needed in order to make it more effective. So we have to have some workers coming.
and I know it's short notice because we're on a time front. So if we're not able to get it in, perhaps written down, a little bit helpful, but we might be able to find some time in the agenda. But I think it would be great to hear from somebody who is doing the work day to day. But
That makes a lot of sense. And Nikki's an extraordinary worker. She was really dedicated to this with the young people and legislation with judges right away.
If you just let me know, we certainly have the written testimony from the House. But if you have the times that you're thinking might be available, I can reach out to me.
yeah, it would probably be Friday, if not tomorrow, which I know is again short notice, but yeah, I'll discuss it with Kayla after this and we'll figure it out. Just want to put that on things. But I know we've had a bunch of questions and that was probably partway through your testimony. So if you have more to your presentation.
I just wanted to clarify another data point. So Tyler, can you pull the there's the next set of data that's on. I know. Well, he's bringing this up. It's down below that. Right there. And sorry, it's falling on 2 different pages. So yesterday, Matthew also talked about the number of 19-year-olds that are attending in criminal division, and there was an assertion made that these numbers would not transfer because some of these cases might get final disposition, for example, or court diversion, as we've already talked about. That's not true. I work with the judiciary on these numbers. These numbers are the cases that would actually transfer. There was like 12 different categories of pending cases. None of those were diversion, because diversion is considered a disposition, so they're not included in numbers. The youth who have already been offered alternatives are excluded from this. So these are cases that would actually transfer because they would lose jurisdiction on 4-1 in the criminal division, so they would automatically transfer to the family division. And so these numbers are actually what we would get. The other piece that I want to add about the alternatives is that over the course of the past 10 years, as we've talked about with Raise the Age, we've also had many conversations and legislative changes around providing alternatives to youth so that things such as probation aren't the only opportunity for them, and that's a response to the brain development and all the research that's done around light touch. and having a response that's unique to their risk. So with that said, we have the opportunity to provide off-ramps, as we call it, to those youth. But we can't control the outcome. So for diversion, the only person who can make that referral are our state's attorneys. If they don't make the referral, despite our making that recommendation, the case doesn't go to court diversion. So we can't guarantee that those off-ramps are going to be afforded to youth. We certainly promote them. Part of my job is to do that and provide support to the community and the broader stakeholders, including state's attorneys, criminal defenders, and the like. But again, we can't control it. We make those recommendations in court. There are other opportunities that Matthew mentioned, also like a direct referral to barge the balanced restorative justice contract that we oversee at Family Services to provide prevention and supports to the at-risk and justice involved youth. But again, we can't control whether or not that actually happens. There are other players that weigh in. So I just want to provide clarity on this data. These are actually the cases. They do not fill those alternatives. Those are already been handled. Yeah.
Okay. Any further testimony? Maybe any questions?
I guess I could. You're gonna ask me a question? Yeah, go for it. Sure you can. So on page 2, I don't get the bill in front of me here, under section 2, it states that jurisdiction over a child with delinquency may be sentenced 6 months ago the child's 20th birthday, or 16 or 17th time they committed the offense, or 21st birthday, if he committed, or he or she committed at the age of 18. I was just wondering, is this something that DCF asked for, and if so, why? Where did this come from?
In the House, there's testimony related to accountability. And so I believe that was in response to the accountability. When we testified in the House, we said we were neutral on this point because what this is, in my opinion, what this is trying to do is provide additional amount of time for youth who have not been willing to engage in the system to engage in the system. What I had said before, and I agree with now, is that for some youth, they might take advantage of that. Some youth have, by the time they begin working with us, as I mentioned, because of long court delays, for example, it's towards the end of their jurisdictional term. So they may have a little bit of a delayed start, but then they say, oh yes, this is a better opportunity, I'm going to engage. So having that additional year may be helpful for those youth. Some cases, if the youth doesn't want to engage and they simply want to wait out the time, that won't happen. So that's why I said we're neutral, because it may have an impact, it may not. I don't think it gets entirely to be kind of the issue, because at the end of the day, the biggest difference between delinquency cases, which is what raised the age is, the delinquency cases, and youthful offender is a higher level of accountability. Youthful offender, we have, and all the other parties have the option to say to the court, this youth did not engage, we're recommending revocation of this status. And the case then goes to criminal court for sentencing. That does not happen with delinquency. They really ended up in nothing happens.
Because I would wonder if someone hasn't engaged with a time period of 3 years, where did you pull the 6 months out of a hat or something? Where does it come from? You know, why not 3 months, 9 months? That makes
Well, so it's 6 months beyond the year. So this is actually adding a full year to what we call extent jurisdiction. So yep.
But to clarify, it's a may, and the may is at yours and the court's discretion.
Yeah, so if we have a youth who, so you're right, we don't have, the term doesn't have to be extended.
Yeah.
DCF makes a recommendation about the term. It's based on our youth assessment screening instrument, which is how we identify the level of touch that word's been used, the level of touch that we feel the system needs to have, which is again why we provided alternatives to probation. But again, with that, we make the recommendation, the court may say, or states attorneys, other folks may say, you know, we think that this needs to be till the end. Even if that's ordered by the court, we can, and the U.S. attorney can petition the court to end prior to that term. And sometimes that's granted, sometimes it's not. It's harder when we're coming in to say, we're recommending that we end supervision because the youth is not engaging, because of course folks want there to be, like, what else can we do to get the youth to engage? So in those circumstances, we may hold the case to the full term, or the court may agree that there's nothing to do. Our system would know that there was an unsatisfactory discharge, but there's still no additional legal consequences for that.
3 years, I just want to add on just a few cases that I've seen, with my work outside the legislature. I mean, 3 years is a pretty standard average amount of time for just about any case. I mean, I still have cases going back to 2019 still that have been resolved. I mean, that's just general criminal, but, yeah. Just want to throw that out there. Senator Burr, did you have a question? No, I thought anybody. Any other questions, comments? Well, thank you. Your testimony. We can take a 10-minute break.